No, no. They need your passport to service. But what do they say? Do they have any other option without? Why do say that? That's exactly. So this is we need to say. If there is something else, I understand, but it is first. Paying on hardware device only. Don't. Because if you are going to say what is the problem or some other there is one program going to start now. Yeah, sure. Open the same laptop.
Fine. ಇಲ್ಲ ಬರ್ಲಿ ನೀವು ಯು ಆರ್ ರೆಡಿ ನಾ ನೀವು ಹೇಳಿ ಇಫ್ ಯು ಆರ್ ರೆಡಿ ಯು ದೆನ್ ವಿಲ್ ಸ್ಟಾರ್ಟ್. ನಾಗೇಂದ್ರ ಹಲೋ, can you hear me okay? Switch it. Okay. Hello, can you hear me okay?
Yeah.
Good afternoon, everyone. I am Nagendra from DPDPA. Today's discussion is being held in association with Rasla. May I request Ms. Neha Prasad to come over? Welcome.
Good afternoon, everyone. Thank you so much for being here today. We're truly delighted to have you here with us. We at Trust Law are committed to staying at the forefront of legal developments that impact our clients. Today, we're thrilled to bring forth the commitment to provide pragmatic solutions as we delve into one of the most significant legislative advancements in our recent times, the Digital Personal Data Protection Act 2023 and the proposed draft rules and its impact on the pivotal piece of legislation on the business development in our country. For this initiative, we are proud to collaborate with the FDPPA. At Trust Law, we like to think of ourselves as more than just a law firm. We are your trusted partners here to walk alongside every legal challenge and opportunity. Our goal is simple: to provide you with in-depth legal expertise and tailored solutions that align with your unique needs and objectives. Our practice spans a wide range of areas, including litigation, arbitration, corporate law, capital markets, private equity, dispute resolution, structured and debt finance, real estate, intellectual property, and media and technology. But what truly sets us apart is our commitment to understanding not just the legal intricacies of your matter, but also the broader business and ecosystem in which you operate. Whether you represent a government department, a domestic, international corporation, or an NGO, we're dedicated to safeguarding your interests and delivering value at every stage. We know that your success is our success, and we take that responsibility very seriously. With offices in Bangalore, Chennai, and Delhi, we're well positioned to serve clients across India and beyond. Our presence in these key cities allows us to maintain close relationships with our clients, ensuring that we're always accessible, responsive, and ready to support you when you need us the most. I would like to extend my warm welcome to Mr. Jaikumar S. Patil. He has 5 decades of experience in the legal field. He was designated as the senior counsel by High Court of Karnataka in the year 2005. He holds expertise in several fields of law. He was approached on 5 different occasions to become High Court judge, which he humbly refused. Shows his conviction and passion to practice law. He's a go-to senior counsel for any junior advocate in Karnataka. Welcome, sir. I now here call upon Soumya to introduce partners at Trust Law Associates and Solicitors.
I'm thrilled to introduce our partners, Mr. Tejasvi Surya, our founding partner and a current member of parliament representing the Bangalore South constituency. Mr. Sudarshan Suresh, a co-founding partner and also the senior partner at Trust Law. Mr. C.K. Veeresh Kumar, our former founding partner and is now a senior civil judge and additional chief judicial magistrate. Mr. Narayan Babu, our senior partner heading the real estate. Mr. Vivek Tiwari, heading the corporate law. Mr. Saina DM for Estate Management, Mr. JP Darshan for Technology, Media and Telecom, Mr. Darshan R for Intellectual Property Rights, and Mr. Akshay Vashisht for Real Estate, and Mr. Jagdish Patel for Corporate and Transactions, respectively. I now request my colleague Neha V to walk us through the agenda for the day.
Good afternoon, everyone. I'm Neha Venkatesh, Associate at Trust Law, and I will be introducing the Digital Personal Data Protection Act of 2023. In today's hyper-connected world, data privacy has become more critical than ever before. Every day, we share personal information, whether we are browsing through the web, shopping online, or even engaging on social media. But how often do we actually pause and think how our data is being collected, stored, or even shared? This is where Digital Personal Data Protection Act plays a pivotal role. Designed to safeguard our personal data, it aims to ensure that our digital interactions remain safe, secure, transparent, and accountable. The key principles underlining this legislation are the data protection principles, including consent, purpose limitation, and data minimization. Rights of data subjects, including right to access, right to erasure, also known as right to be forgotten, and right to data portability. And lastly, accountability, ensuring that entities processing personal data adhere to compliance framework and safeguard individual rights. The reason we are all gathered here today is to deliberate on the concerns, challenges, and potential impediments businesses and organizations may face in complying with the draft rules once they come into effect. As we dive deeper into these concepts, we will explore how businesses can integrate data protection into their daily operations and how individuals can better understand and exercise their rights in the digital age. Protecting the personal data is not just a legal obligation, but it is essential for building and maintaining trust in this today's digital landscape. The Act, introduced in August 2023, marks a significant milestone as India's first ever comprehensive data protection law. To operationalize key provisions of the Act, the Ministry of Electronics and Information Technology published draft Digital Personal Data Protection Rules on January 3rd, 2025, which is currently open for public consultation. The last date to submit public opinions on these draft rules are on February 18th, 2025. Once finalized, these rules will play a crucial role in shaping the implementation of the Act. In this endeavor, we are honored to be joined by Mr. Vijay Nagaraja Rao, fondly known as Mr. Navi, the founder of FDPPI, a pioneering organization in data protection practice. Now, I invite Mr. Sudarshan Suresh, Senior Partner at Trust Law, to share his insights. Thank you.
Welcome one and all who gathered here. We are delighted to have you in this endeavor of knowing the law and also the nuances that has been attached with regarding that. And this discussion is going to be a kind of an open-ended discussion. This discussion will be super and overviewed by by our moderator for the day, Mr. Vivek Tiwari. And now I call upon Mr. Navi to walk us through the Act and the draft rules.
Thank you, Sudarshan, dignitaries here and my friends. Okay. Our objective for today is to actually get a feedback from the industry on the rules, draft rules, which the government has notified, so that by the time we present the comments on 18th of February, we will have some idea of what the industry thinks of. And of course, comments can be sent directly by any one of you to the ministry. We also, of course, DPDPA has been regularly submitting such comments. We will try to do that. So while by this time, most of you are already aware of DPDPA rules and even the Act, I would not like to go deep into the Act at this point of time. I will actually go through the questions related to the rules. Okay. And then I would like to get a feedback from you. In fact, we wanted to have this as a roundtable conference, okay, so that there will be more participation from each one of you. And therefore, I will be raising specific questions which can be answered by any of our panelists here and also by any of you. Answer in the sense that your views. Okay, there is no answer here because the government is yet to formulate the rules. So the Act is already there. Nobody can touch the Act as of now. Okay, so if at all we are actually saying anything about the Act or the rules, it is an interpretation which we have about the Act. In fact, we feel that the rules also has to be well within the Act. So therefore, the Act becomes the hard-coded matter. It cannot be touched. Okay. Rules, the government has given certain draft rules. And as an industry, if you have any specific issues which feels that this rules is not compatible to your activity, this is the time for you to bring it to the notice of the ministry. Even then, I am not expecting too much of change in the rules, but whatever suggestions are made now will perhaps be kept in mind by the government as and when they implement the other aspects of the rules and the data protection board comes into being. Okay, so that is the objective of this meeting. Just for the sake of refreshing your minds, you know that the DPDPA is Digital Personal Data Protection Act. It applies only to the digital personal data applicable to data generated in India. It does not apply to GDPR data. So it is not material if you are GDPR compliant or not. If you are GDPR compliant, then check whether whatever compliance controls you have put is for EU data. If so, that will continue. You don't have to make any changes. But if you have applied GDPR controls to the Indian data, then you need to change. You cannot assume that we are GDPR compliant and therefore I can go ahead and consider myself as compliant. Similarly, if any organization thinks I am ISO 27001 compliant, I don't have to do anything, that is also not correct. ISO 27001 compliance applies to the personal data which needs to be protected under one of the provisions of this Act and the rules. To that extent, it is relevant. But industries should not be complacent with the fact that either I am GDPR compliant or ISO 27001 certified, and therefore I can take DPDPA lightly. DPDPA 2023 cannot be taken lightly because in Indian circumstances, no other law said 250 crores plus penalty. This is the one law which says that companies can be imposed 250 crores plus penalty. So it has to be taken seriously. We can always say that government is not going to impose the penalty tomorrow. They will give another 1 year, 2 years, all that is fine. And even after that, one can always negotiate with the data protection board. They also may provide more time. But as a responsible company, I would not advise any company to actually take DPDPA 2023 compliance lightly. You should have been in compliance by this point, this time, even before the rules come, because this DPDPA 2023 is just an extension of Information Technology Act, which has been in existence for 20 plus years. And from 2011, there is the sensitive personal data protection rules, which all the organizations, I'm expecting that there are a lot of corporate entities here, apart from the advocates and others. So you must have been compliant already with SDPI rules, and therefore this is just an extension. If some company is not yet compliant with SDPI rules, I can say that you are liable under ATA 2000 even today. So if you start complying with the DPDPA 2023, perhaps it is good, okay, because that is the responsibility of an organization, okay. So that is what I would like to just say in brief. Applicability, roles of the organization. What do we mean by roles? Is whether your company is a data fiduciary or a significant data fiduciary or just a data processor. These are the things which you should be clear by this time. In any company, you should know today, if I ask you a question, are you a data fiduciary? Obviously, everyone will be a data fiduciary, because the processing of personal data of employees is there with every company. So there is no company which is into digital world today which is not a data fiduciary. The only distinction is whether you are a significant data fiduciary. Government has, I will discuss that rules separately, we will discuss that. Government expects you to make a self-assessment and decide whether you are a significant data fiduciary. Government will come later to impose penalty if you have made a mistake. That is how the government is approaching this. There are certain obligations. Obligations include protection of certain duties of the certain rights of the data principal, and data principals also have some duties. These are all part of this particular act. In case there is a data breach, there is data breach notification requirements, and also there is the penalty, which I already told you is 250 crores. This is the DPDPA Act in a nutshell. Now, yeah. Okay, with this background, let us now go into the DPDPA rules discussion. Okay, I would elicit responses from the head table as well as from any one of you. If any more clarification is required, we will try to do that. Okay, if any of you would like to know what is the DPDPA rules, I can actually display it there. Okay. Let us start with the first important aspect, which is, when is this act applicable? Okay. Now, I know that some of you have already studied the rules. Okay. Now, the rules says that there are 4 or 5 rules which will be effective on the date of notification. Rest of the rules will be coming subsequently. These 4 or 5 rules relate to the Data Protection Board, but it doesn't say that according to this rule, the Data Protection Board should be in place by tomorrow or something like that. It only says a search committee for selecting or choosing a chairman and the members will be set up. That is one of the rules which is going to become immediately relevant. Now, the question which I would like the law firms and others to also think about is, because if somebody is not compliant, or even otherwise a company will come to your firm and say that please let me know whether I am compliant. So we should be able to tell them since what date you are supposed to be compliant. Okay, so that's why it becomes important to start with this date of application. So now I would like somebody from trust law to respond to this particular aspect of since when we should consider this particular act, rules and act be considered as applicable. Any thoughts on this, Sudarshan? Yeah.
So, as I understand, or as I perceive, it's on the appointed day when the rules have been released from official gazette. So that's
Okay.
when on and from that particular date is what the rules will be in effective and force, will be in effective and force. And that's all. We'll have to consider about being compliant about the rules.
So you mean to say that we have to still wait for that date to be announced? No.
Now itself, we'll have to do a background work with regarding
Okay.
that, and all the nuances that have been arranged.
Okay.
That is the
Now,
whole purpose of this, where the draft rules.
fine. The draft rules are there. Government is collecting public views before February 18th. Afterwards, another 15 days they may take, and then perhaps confirm the final rules. Is that the date on which we should say that this act is applicable? You have got any view of it?
Yeah, so I think if you look at the legislative process for bringing any law, any significant law in India, there are largely three kinds of things that the government follows. Either what the government does is that it notifies certain sections of the law, as is the case with Companies Act, and then subsequently notifies a few more, giving the time to the industry to be prepared. The second one is that where the government goes on the gravity of the players involved. For example, which by the way is the distinction that they have done in this rules also. I'll come to that. So what you can say that, okay, companies having a net worth of 500 crores need to follow by this date. Companies having a net worth of 400 crores need to follow by this date. And the third one is where you subsequently increase it to the various players. As far as DPDP is concerned, I don't think the government has done that distinction in terms of the application of the act. The act applies from day one to everyone. What the government has done is by introduction of the significant social media intermediaries and other large players, I think the parliament and the legislative bodies are acknowledging that we are going to ask for higher degree of regulation and higher obligations with people who are collecting large amounts of data, as opposed to people who are collecting smaller amounts of data. Either the initial thing will not be so strictly put into place, or I feel the government may give a kind of a sunrise period, saying that, okay, by this date, you please be ready, and I'm going to make these particular provisions notified on that date. That is how I feel the government will play out.
Thank you. So what Vivek has suggested is that irrespective of the size of the organization in terms of turnover or in terms of employee size, GDPR has got this 250 employees or something like that. Whether any industry is classified as SME, MSME and other things, this law doesn't make any distinction. So the law will become applicable when it is applicable to all persons. Okay. Now, as an industry person, now it is for you to react and speak to the government today if you feel that this provision needs some kind of moderation. For example, what is applicable to State Bank of India, it is also applicable to a small fintech company or a cooperative bank. What is applicable to Apollo Hospital is also applicable to the pharmacy, neighborhood pharmacy, or a nursing home with only 4 or 5 beds, a lab which is doing only a few tests as against somebody bigger. Now, the industry has to respond. Are you ready for the implementation across the board, or would you like this kind of segmentation of the date of applicability? Is something which you need to think about it. So in case many of you have not thought about most of these things, please note it down and kindly forward your suggestions to us, okay? So that we will try to incorporate it in our recommendations. And if you want, you also can directly send your recommendation. I'm not saying that all recommendations have to be routed throughout. as or with the trust law. Trust law also can make its own recommendations. But think of these points, whether the law should be applicable across the industry, irrespective of the size, or should you make any other change. Remember that the law is applicable even to an individual who is processing personal data for non-domestic purpose, which means business purpose. If there is a proprietor who is processing personal data digitally, he is also as much liable to, say, reasonable security safeguards. Some of you may immediately relate it to ISO and other things. What will that proprietor know about all these things? Okay, so is this the right approach, or should there have been any time schedule? As Vivek was saying, should we say this was done in HIPAA also? Okay, up to a particular this thing, it will be applicable on a particular day. Small entities will be given 1 more year time, 2 more years time. Whether this is to be suggested to the ministry is one point which I would like you to take into note. Other than that, one thing we should notice is currently the 5 rules which are going to be considered as applicable on the date of notification of this, which may come, let us say, in March, will only talk about setting up of a search committee, but it doesn't give any time schedule for the search committee to complete the selection of the chairman or the members. In the earlier drafts of PDPB, there used to be a 3 months time or something like that. So if there is no such time period, is it possible that this implementation gets unduly delayed? Because until the Data Protection Board is formed, they set up their website. Rest of the things from the industry cannot start. That website has to be there. There has to be some contact to these things. There has to be references and so on. Similarly, in the rules, if those of you who have gone through the rules, there is the rule number 22, which talks about the government appointing some officials. One of the officials is a person who will be deciding about who should be called a significant data fiduciary. Okay, what class of data fiduciary should be considered as significant data fiduciary? There has to be an official. Now, when will that official be appointed is some of the things which I would like to be added in this rule 1. That official also, let the government commit that official will be appointed, let us say 1 month from today, 2 months from today, 3 months from today, something like that. Otherwise, we in the industry will not know whether I am a significant data fiduciary or not. Without that, you will not know whether you should appoint a data protection officer or not, whether you should have a DPIA conducted or not. These are all fundamental requirements of compliance which remain a gray area if the definition of significant data fiduciary is not specific. So this rule 1, which appears very simple and says the first rule 1, section 1 and 2 will be applicable, 16 to 20 section will be applicable, kind of a thing, is actually looks simple, but actually it has got a lot more intricacies. Okay, we'll come back to that later on. Okay. Now, one of the things this act has done is there are no separated rules has done is there are no separated definitions associated with the implementation of the rules. It was there in the earlier draft rules, but it has been removed, which means that all definitions will be only what is available either in the Act DPDPA 2023 or in certain sections they have mentioned that they will follow the Information Technology Act. Okay. So one question which people like you should ask is there any term in these rules which require a specific definition which is missing? For example, somebody was asking me on the other day, ITA 2000 has got terminology intermediaries. Does an intermediary also fall under DPDPA 2023? These kind of questions. Okay. So I would like somebody from the audience to give their view. Is the lack of definitions in the rules is a lacuna, or is it okay? Yeah, and Kodanram, Advocate Kodanram, yeah.
Thank you, sir. Regarding the implementation part first one, I feel we should start implementing. We should not wait for.
No, I understand that, but my question now is this one.
There is any need of explaining who is the intermediary.
Okay.
Intermediary is the guy either stores it or processes it or acts as an intermediary who himself is a fiduciary. If you look into the process definition, it includes even mere storing. It need not be something dynamic that is going on. Even simply keeps it as a treasury or keeps it as a archive or whatever we call. Still, there are called processors, either processors or fiduciaries. If they are taking directly from the customers, we can call them as fiduciary. Fiduciary document, wherever your background is, you can call it as processor, and the responsibility comes to only to the fiduciary, not fiduciary.
Now, shall we say all intermediaries are data processors and all data processors are intermediaries? Yeah. Vasantika, yeah, please introduce yourself for the first time at least.
That will continue to apply, in my opinion.
Yeah.
So the only thing is, depending on what is the nature and purpose of the intermediary. If they are determining what data they will collect, whether they will process, how they will process, will determine whether it is a processor or a fiduciary. If they are doing it on behalf of somebody else. So just the fact of somebody being an intermediary will not necessarily make them a fiduciary or a processor. It depends on how each intermediary functions.
Okay, this is just a warm up. Okay, now we will go into more serious questions. Okay.
I think he has a point. Sir has a point.
We will come back again and again. Don't worry. Within our 1 hour, whatever 22 points we have to cover. Yeah, please go ahead, Madhu. Madhu is also an advocate.
Basically, what could have been more better defined in the rules. There is this, one of the legitimate rules is for the purpose of employment. If you look at section 7I.
Yeah.
And that's very generic. And some of the employers today are significant data because the sheer size of the number of employers they have. And because today employers use the employees' information for many purposes, probably there is a borderline of whether all of them are employment purpose or not. Some definition or some kind of a schedule as to what constitutes employment purpose, what doesn't constitute employment purpose.
Yeah, that's a good point. The legitimate use basis is available for the purpose of employment. Okay. And of course, the Act gives a little more clarity in the sense that when you say for the purpose of employment, it is for the purpose of securing the company in terms of, say, information security, fraud prevention, and so on. But still, a kind of clarification is what you feel is could have been given. I'm just taking note of it. I'm not say getting into any debate on these things at this point of time. Only to ensure that others understand what you're saying, I'm just repeating that. In the operating this thing, we look at employment cycle. That is for data for personal data processing is pre-onboarding. Okay, where the person is only an applicant, he is not an employee. Whether processing of personal data in that pre-onboarding stage can be considered as for the purpose of employment or not is a question. Then while you onboard, then sometimes we do a medical test and other kind of things where sensitive personal information also is being processed. Whether it is okay to just leave this gray area there is a question. Then once the person becomes an employee, we get a employment contract. then for the next 20, 30 years, he is bound by the contract. But there is a post-retirement aspect also. Or when a person leaves the organization, what happens to that data? Whether it is still considered as the data of an employee is one of the questions. Or it should be considered as a outsider's data and you apply whatever legitimate, legal basis is required for that purpose. So this clarification perhaps is required. What we in FDPPA has been interpreting is that let the government not give me too much of a checklist-based interpretation. Okay. If they give it, then my ability to interpret to that extent becomes less. Okay. It's like we all want innovation, is it not? Industry wants innovation. Okay. Legal people also want innovation. We want to create our own jurisprudence and convince the judge at the particular point of time that this is for the purpose of employment. Okay, let us debate it in the court. Okay. So therefore, the more detailing which the government gives, I am slightly uncomfortable because that becomes a straitjacket kind of a thing. It only helps us to find some loopholes this way or that way. So that is my personal view. If you have any.
Sir, I mean, since we're just talking about the lack of definitions, the expressions legitimate uses, the expression has been repeatedly used. But what falls under the ambit of legitimate expression, legitimate use, and what does not fall? I personally feel that there is some lack of clarity both in the principal legislation.
Yeah.
How do we address that? I think this is one of the aspects that we need to bring it out in our representation for the comments.
Yeah. If our senior advocate wants to comment anytime, you please let me know. Okay. Jagan from L&T Mindtree. No, take.
The employment aspect, it was very clearly addressed in the consultation that we had with the ministry. Firstly, they clearly said employment starts only after they join, so at the time of offer. So before that, it is pre-employment, it is not considered as employment, so you have to adopt the consent. The second thing is to answer this question on what are the uses, because the organization can use the data for whatever it is. That has to be very clearly called out in your notice to the employee. Right? You have a prerogative to publish a notice to the employee to process personal data. As long as you call that out very clearly, then you are obligated or you are allowed to go ahead with it. If you are not calling it out, then you probably have to reissue another notice. If you are changing the purpose of being the processing, you have to call that out again specifically, may make a communication. Post-employment, they said as long as it is in line with any legal requirement, for example, PF, right? When PF needs to keep a record of your data. At the same time, you need to keep a record of the data. And so on and so forth. And retirement as well. I mean, if there is an obligation by law, then you can keep that data. Or if you have any other requirement or any purpose that you need to keep the data, that needs to be called out very clearly and specified. This was very clearly debated during meeting consultation, and this is the answer. So we have enough clarity on that. What I was doing.
Okay. So thank you for, say, Mighty actually had a few consultations. He's talking of one of those consultations. So there's some clarity, pre-employment, post-employment. Okay. Now, if you agree with that, it's fine. If you don't agree with it, then you can always put your suggestion. Yeah. Mr. Subrayadu. Yeah, you give that. You have to switch it on. Okay.
Yeah, it's working. It's working.
Yeah.
Just a question. It says for the purpose of employment is only start. The interpretation, and I would like to respect that. If they had the body in due course of employment versus what the government.
Okay.
It depends on the definition that given choice given right now.
No.
In due course of employment.
This is the reason why I don't want ministry to give out any kind of interpretation, because whatever they say in public forum, that becomes subordinate law as far as we are concerned. Okay, we will call Mr. Jagannath as a witness in a case and say, is this what ministry told you before you this thing? Okay. 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 Okay.
It would logically include all the steps that have been taken pre-employment, post-employment.
Right. See, at this point of time, what we as compliance people are suggesting is, please develop a policy in your organization, adopt that as a policy of how you define this legitimate use for the purpose of employment. And I think you should be able to justify that and argue at the appropriate time. Of course, see, whenever you use legitimate use, it means that it will be the last resort. Where you cannot get the consent, then you take legitimate use. You don't use it as the first basis. Therefore, if a consent can be obtained, please obtain the consent. But suppose consent you have taken for 2 or 3 things, during the onboarding, a fourth kind of processing happens, then that is the time when you have to invoke this legitimate use, and not as the only way by which you will process the information. This is the DGPSI view. DGPSI is digital governance and data governance and personal, protection standard of India, which we have adopted. And in that, we are trying to give our interpretation of the law, which is like our best interpretation. It is jurisprudence kind of a thing. So we got now very interesting difference of opinion between 2 industry persons. And one of the persons is also saying this is what the ministry also thinks at this point of time. In fact, I did point out to the ministry recently, saying that you have to be circumspect on what you say in the public. Because whatever you say in the public, the people will, who will take it as their view, will perhaps say that this is what the ministry view is, whether it is put down in the rules or not. This risk they will be taking. Okay. Now we'll go to another important thing, which is the legacy data. Now, when we are on the notice, okay, this law requires that you should give a notice to all your legacy data principals and take the consent. Is there anything which you as an industry person want to say something on this legacy data, how easy it is, how difficult it is? Rajan, you have got anything to say on this? Anybody else?
30 years ago.
Yeah. This is one of the most important problem areas for the companies today. Yeah.
I'm Major Dr. Pramod in actually forensic medicine expert, because with legacy data I'm taking it, is it like after death or after employment? So one of the, so what will happen to the data of, let's say, postmortem or any other thing that will be held by the hospitals or medical colleges? Like we have a software that has been done as a forensic integrated workflow management system. So the consent is not there because the person is already gone. Is it the next of kin who is supposed to give consent? Or is there any provision that how the digital data?
I think that's where right of nomination would come in, right?
No, wait. But what he's saying is, in the legacy data, there are certain kinds of data on which I cannot take the consent. He is giving one example. We may also have similar things in the industry, because I may not have the working email of the particular person or other reasons. He is talking of a very specific thing where the person himself is not there, who has to give the consent. But that is also a special legitimate use basis on what we call as emergencies. It comes under the emergencies, and also if the postmortem is being done because of some legal requirements, you may have exemptions from consent. Okay. Only
I'm also an ex-army doctor, and then what has happened, like for the armed forces processing so much data, it comes to the life insurance, like the soldier is killed in operations. And the data of course, there's an army group insurance, but there's also a private insurance, that it could not be a life insurance.
See, this kind of instances or contexts will have to be properly documented during the compliance, this thing that you say that my organization has this kind of data, this is how we are going to treat it. Yeah.
Yesterday, I was also talking to a healthcare hospital. So since we spoke of that, and their worry was, they have been in operation for almost 20 years. Everything is fresh from the day they started. So there are, in those days, we all only had landlines.
Agreed.
It doesn't necessarily have a mobile phone in those days.
Yes.
So now, and they are preserving all that data.
Yes.
Now they have to call, take consent. Most probably, those people don't have that landline number anymore. We don't have their mobile number. They have not given an email address, and they have to go back, seek.
Now, what is your suggestion? Now, if you want to suggest a modification to the ministry, what is your suggestion? That is our immediate objective.
Maybe there should be some kind of a cutoff time.
Okay.
Within which period we have to
Okay.
see.
Now, this may be sector wise also, there may be some reason to think. So I would like all of you to think for your sector, what exactly you would like the ministry to do. Yeah.
So, sorry, somebody.
Yeah. He's from Coin DCX. Okay.
Fintech perspective is especially challenging because we have got a lot of KYC data that we have collected for specific consent. Now, from the fintech perspective, what we would want at a minimum is that the legal exception which has been carved out should be extended to the legacy data as well. Because by law, we are required to preserve that data under the PMLA for a long period of time after the completion of the relationship with the customer. If that protection is not extended, then that will be concerned. So that would be one suggestion. As Navi sir was saying, an industry-specific suggestion. This would be a suggestion that the legal requirement protection should be extended to legacy data, especially when it is collected to fulfill my legal responsibility.
Yeah. I think somebody is noting down these suggestions. We will keep it here.
I just have one observation on this entire thing. I think the problem lies if you are not able to see. DPDP is a consent and notice heavy law. That is the primary objective, as you, sir, was also saying. If you are not able to fulfill the notice and consent aspect, then you go into legitimate use and you start exploring that. I feel that if you are not able to get this consent mechanism from a fresh date for your legacy data, either because the credentials which you have in store are no longer relevant, or because the person is no longer there in the world. I feel that, to ask the organization to completely erase it from their systems and servers, itself is a humongous task. Because you can think about erasing, but the kind of difficulties that you have in the other connected systems that organizations have will be phenomenal. But what I definitely feel that the government is keen on doing, and this is something that we have been talking to, whoever we know and what we feel, is that the government slowly wants it like a tide over. They want a particular point in time where the legacy data will no longer either matter because of virtue of passage of time, or because the purpose of that data is dissolved. So I don't think the government will give you the leeway to continue with your legacy data forever. What the government will say that either you re-verify it through a consent mechanism, or you use it for legitimate reason, or you use it for certain number of years. But after that, please put a curtain on this. Because the idea is that the government does not see if the government is. Now let's try to make an example of a legacy data with a new data which is collected. If in the new data your collection is only for X, Y, Z purpose, okay, and you want to now take it for A, B, C, I think all of us will agree that the best thing is that you again trigger a consent mechanism. How do you do that with the legacy data? How do you determine what this legacy data was captured for? Even if you are able to figure out that, okay, this is the legacy data which is available, it is very difficult to figure out that what that legacy data, what was the purpose for which that legacy data was captured for, because organizations pivot, they go into new business areas. You may have an organization that started, let's say, as an insurance agent, and then they went into broking, and they are using the same legacy data. So our inclination or our understanding is, and as it goes deeper and government gets more and more involved in the data, goes more and more involved, We feel that it will either fall in these three categories. You do a reach verification by triggering your OTPs or whatever it is. You're not able to do your reach verification, please ensure that you are able to establish that you are using it for a legitimate purpose. If none of this, then at an outer timeline, you will have to release that data. Is our inkling, but as he said, all of these are just thoughts, and the idea of this session is that we all are able to take each other's perspective. Please go ahead, sir. Not really. I would say deletion is not in the purpose of processing. In fact, deletion is the final act by which I can be confident that you can no longer process. Okay. Yeah.
So it is not only by deleting legacy data. I mean, legally speaking, it's very able to interpret it in that sense. Even by deletion, you have done it processing of data.
See, there is one reference in one of the rules saying that certain kinds of organizations will treat 3 years as the time after which the data may be deleted. But even before that, you have to give a 48 hours notice. Now, for the legacy data, you must make an attempt to get the consent. There is no doubt that this is an essential requirement of compliance. Now, where you have the email contacts, you must send an email asking for consent. Now, where you do not have the contact address, perhaps you will have to release a newspaper advertisement or something like that. Ultimately, you have to take the business decision that if the data is old, its value has diminished over a period of time. If I cannot verify the data, say verification of this consent is also required under Information Technology Act after every year. Okay, so there is already a law for that purpose. Now, if I cannot verify that my data principal is alive, existing, not existing, and all not, what is the use of that data in my database? Am I not carrying a liability of that? So, you have to think from business perspective, what is the value of the data for which the age has gone beyond a particular level.
With
Now,
the advent of AI, every data, all data is valuable for all the companies. So there is no question that, okay, that's.
it's okay. Now, if somebody has got a credit card data of 10 years back, how valuable is that?
It will help you build large language, the pattern. No, that is
Okay.
exactly why all these Googles and all this.
No, wait. We'll come to that.
Then each priority of data should also be taken a look at. We handle a lot of DevTech startups. I'm Major Arun, I'm from Center for National Security Studies. We handle a lot of DevTech startups, and we have the should also be taken into account for DPDPA compliance.
The AI is one of the biggest excuses industries are using to do what they want to do. What does the rules say about AI? It says that algorithmic processing is the responsibility of the data fiduciary. Of course, it is there in the significant data fiduciary category. But if you are using AI, it doesn't mean that you don't have a responsibility. You as a user or deployer of AI, you are a data fiduciary. It is open to you to get an undertaking from the AI supplier and transfer some responsibility to him as a joint data fiduciary, but you cannot escape the liability. That is one. Second, if you want, you can use any data. But AI, large language models, doesn't require identifiable personal data. Why does it want the name and the identity of the person? You anonymize the data and use it. So identifiable personal data does not have a requirement under LLM. So if your legacy data is important, for example, medical kind of a thing, that data is very valuable for the community. There is no doubt about it. But it doesn't, is not necessary that the particular person was A or B or something like that. What we need is the age or whether it was male or female or something of that nature, not the identity. So In the legacy data, if you feel something is valuable, please anonymize it or de-identify it to the extent necessary, and then think of making proper use of it. So it is not a blanket permission that I will not do anything because it is valuable. Okay.
I'm being a devil's advocate here. So unless there is a penalty on, my.
Okay.
Why would I have to invest on?
I understand. So one of the suggestions we will be making to the ministry is, please start imposing the penalty in the first day.
Exactly.
Otherwise, industry is not going to respond. Is it acceptable?
I have a suggestion. Completely deleting it, you can also provide for masking of it. So that would be one of the suggestions that we could.
No, what I have.
We are forgetting retention policy.
No, wait. Say, no. No, we will only. No, wait. My objective is to gather as much of feedback as possible, not going to the details, because you know me. If you want to discuss it, we will discuss until the end of the day.
The principle is very simple. Change it or challenge it.
See, technology companies work like this because they
Should not. Say, technology companies have to change. They cannot challenge the law. Okay. Government has brought this law for protection of privacy, which is a fundamental right. Okay. Now, if technology people are not happy with it, please challenge, put us on a judgment. You ask for a 13-member Supreme Court bench to take that, yeah?
Please go ahead.
Legacy data, while it's not going to AI and all of that. But there are very practical issues. I come back to employment. For example, there are so many problems on trust with employees themselves, right? Everyone has saddled with people who are working with them, and there is data, and that data is linked to the number of money. And I'm on the board of trustees of EPFO, and EPFO, the right contributors of 7 crores. Not like total contribution.
All deletion is subject to no other law requiring it to be retained. So the law does not force you to delete when it is required under a PF law or something else. So it is there. So that provision is there. That's why I mentioned ITA 2000. If somebody said KYC data, you have to maintain for 5 years under ITA 2000. Obviously, you are not required to delete, because if you delete it, you will be violating Information Technology Act. So that provision is there in the law, that it applies only to where it is not required to be retained. This is where compliance people have to look at the legal people and ask them in the organization. Today, many companies do not know how many laws I have to be compliant with. Is it not? If you ask lawyers, they will give a laundry list of 100 laws or something like that. It is in our DGPSI, we have said DPO will check with the legal department before taking a decision on deletion. There is no right to forget automatically by the DPO. It has to be referred to the legal department and the data governance committee. This is what we have said. And additionally, if you look at FDPPA's recommendation, we have suggested that government should take some responsibility, because industry will have this doubt whether I should delete. What if tomorrow he comes back and says, I want this data? Will he file a case against me for deleting it? Something of that nature. We have suggested government should come up with a national archive of personal data and transfer this kind of data to that national archive. Let the government take the responsibility of secured retention for any number of years they want. And later on, my responsibility is no longer there. Same thing will be required when you have this nomination and claim settlement. Claim settlement is not an easy decision for any organization. There will be legal issues. For years, you have to maintain the data. I don't want to retain that data as a business company. So this national archive can be used for archival of data which is provisionally, it ought to be deleted, but I don't know whether I should delete it. That kind of gray area matters. And also for unclaimed data, and where there is a nomination, but nominee is not available, something of that nature. So This is a suggestion which we have thought of. You can either accept, add it, or give your own thoughts differently. Okay. So anyway, that's a suggestion like that. We'll come back. We'll go into the other.
Corporate end or anybody, sir, it's an easy way to overcome on legacy is, one, there are steps to be followed, as you rightly said, policy has to be created. First, they have to send for consent and notice with the users wherever the database is
Yes.
available. If there is no consent, explicit consent is obtained, you have to move that data, you are not first of all authorized to use. If it is linked with any kind of a legal provisions data, like either a legal or probably in the medical, whatever aspect, it has to be moved into one system with an encrypted form with a limited user access.
Yes.
It cannot be in your regular system which the data flows on. Third way, you don't have a data, you have a data, you don't know why the purpose of the data as he was indicating, or how am I going to use. So it's also as a concern AI or whatever future technology completely don't encrypt or probably mask it or anonymize it, use it for an LLM purpose where the data is no longer considered to be a personal data, it qualified as a non-personal data. It will be outside the ambit. I think these are all the 2-3 aspects that we always related to.
This is the difference between archival and deletion.
That should be from the organization perspective.
No, correct.
I
So-
to the extent of your view, but not at the national level, because you imagine the term for the college or quantum of amount if like a company like us is going back and depositing it. One, this is going to be unnecessarily cost and administrative issues going to be creating in the system. And even if it's any hacking or leakage happening, right, you may not.
Okay, you know what you are saying is that the company itself can archive it. There is no need for national archives. Agreed. Okay, I leave it as your suggestion.
One more solution for that.
Yeah.
It is better, some exemptions are given for certain medical legal issues.
It is already there. It is there.
Chemical for legacy issues.
It is there.
No function available. Consent is not taken.
Yeah.
Still it can lie. Because if you go to any other case, it doesn't serve the purpose. And it is required for the posterity, for the benefit of the mankind. In such cases, it is always wise to see that it remains with them active, even presently.
Certain exemptions are there. It has to be put into the policy documents. That is where you should know how to put the policy documents so that tomorrow if you present it to the court, the judge should accept it as an reasonable policy the company has adopted. Okay.
Why, there's no consortium of healthcare professionals.
Yes.
Healthcare industry, fintech industry.
Now you ask people who are here why they have not made an association of these things. We have been talking about it for a long time. July 27th, we raised this issue when we had our conference. Industries are taking it lightly, for example. Okay. They don't want to act. They want ministry to give a checklist and they will have an AI software which will check and give in 1 minute, I am compliant. Okay, legal compliance is not going to be automated like that because every interpretation has got multiple interpretations. 2 lawyers are there, each will have a different view. So industry should actually give up their thought that you can simplify your process by automating with a checklist, and they are actually bringing pressure on the ministry to come out with a checklist, which is what I have personally been cautioning the ministry people. Please don't do that. Okay, it is easy for them to do that. Okay, and in GDPR and others, we have seen plenty of such directives coming directly from the EDPB. If it comes from the working party, it is okay. Like FDPPA can issue any number of clarifications. We are not the government. But if the government comes out with a clarification, that becomes a law. If their clarification is not in tune with the law, there will be somebody who will be questioning that it is ultra-vires the law. The rule is ultra-vires the law. People are waiting to bring stay on the rules for that reason. So that is what I am trying to say. Let us, the industry, take the responsibility of interpreting. And if anything goes wrong, that is the time when the risk absorption of an organization comes into question. It's not that 100% risk is anyway mitigated in any situation. You always do something which is to the best of your ability. then you always leave certain risk to be absorbed either through insurance or through something else. We were discussing some time back about what is the business prospect. Cyber insurance is one of the biggest business prospect which is arising out of this DPDPA. Yeah.
It's 2018, we are like, going on seeing all these announcements. These people don't, not taking it seriously.
Agree.
There's no clear.
No.
No,
Agreed. No, agreed. That is why I'm saying that I'm getting a thought that I should put it as a suggestion to the government that you start giving some penalties as early as possible. Don't give 3 years, 4 years kind of thing.
I just have two thoughts. And first of all, it's very good that there's such large participation about things. See, on your AI point, I think, I can draw a parallel with the intermediary rules. In the latest judgment that is happening around Meta and everything, where basically people are taking the benefit of safe harbor provisions. So Mighty has come out with various advisories where he is saying that if you are simply a passive provider of data and you are using any kind of AI ML tools and you are interacting with the data, it is your duty to highlight to your users that this is what you are doing. I think if I have to draw the same parallel, I do not see that only because you have mass data or whatever it is, and you're using an AI tool. If there is a leakage out of that, I don't think you can escape. Regarding penalties, see, my view has been, now I have been a corporate lawyer for 18 years. I think with every regulatory body, and it is especially true if the regulatory body is a central regulatory body. I can give you the examples of SEBI, the Competition Commission. I think they grow stronger with time. It's not that on day one they are very strong, because you have various chairmans coming, there's jurisprudence which is adding up. As opposed to this, if you actually compare it with a state regulatory body, something like RERA, it takes a much longer time for each RERA to be very strong because you have a lot of state level, for want of better word, manipulation into the process. So what I feel is that to expect that the data board on the day one is going to be a super packed body and it is going to go out all guns blazing. I don't think that is how it will be. I think you will notice that the data protection board which is formulated, because if you see the entire journey of this act, which you can say is whatever 5-10 years, I think there are 3 significant things which has happened in India's space. First is along with Aadhaar, the amount of big data which has started coming from 2012 onwards. Second is the amount of monetization of data and the kind of digital infrastructure Indian government has invested in, what we call the India Development Stack. And the third thing is that if you compare it with the act which came in 2019, 2018, they have moved away from GDPR. GDPR was 2016. I think it came somewhere around 2016, I think. 2018. 2016 they introduced, 2018 it came. I think if you wanted it as tight as that, it would the government is going to come out and start finding people and suddenly put the industry in a strike. I don't think that will happen. But year and a half, you will have a few cases slowly coming, and suddenly the jurisprudence will start building, and you will see the Data Protection Board becoming a very strong body, probably in the same league as the Competition Commission of India, the SEBI, and all of that, where their judgments will start becoming much more stricter and much more stronger. That is how I foresee this to be.
No, that's correct. Because India wants investment from outside world, and then if companies are being fined right away, it's not coming.
We'll come to one more point on this need of the international companies to make profit from India. Now, data localization is another area which is having the same kind of discussion, that if we have data localization, international companies will have problem because they cannot make money out like they are making today. Now, data sovereignty is also a requirement for our country. Why should we look at only the interests of Google or Microsoft or somebody like that and not the national security and other issues? So data localization, as you have seen, that in the original act, government had been a little silent and they had only put an empowering kind of a clause saying that government may notify countries to which the data need not be restricted to be transferred. Now, in the rules, they have slightly tightened it, saying that we will form a committee and the committee will decide what type of data need to be restricted and what type of organizations need to be restricted. It means that you are not going to have X country is the country to which you can transfer the data or something like that, which GDPR uses. Now, of course, there are also some specific sectors could be there that in this particular country for such these things, it is permitted, something like that. This will be more specific like that. That is, the restrictions on data transfer outside India will be defined on the basis of the type of data and the country. So I may say that you cannot transfer it to USA if it is a financial information. That is the data localization policy of RBI. Maybe the RBI is present, this thing is not applicable to health data. So government may either restrict health data or they may not. So you may be able to send health data to USA, but you may not be able to send, say, credit card processing data to USA, something like that. Each sector will have a distinctive provision on cross-border transfer. So this is another thing which industries have to think, whether this kind of a thing will help them, not help them, put them into restrictions. If so, this is the time to respond. Okay, anybody else wants to add to this cross-border transfer? Yeah.
I think I like this new concept that national archival of data. Because it was so happened, the company itself get dissolved because of some reason. Or the company, like, to give an example, the guy you work for, they are closing their India operation, they are permanently going back. So in that case, data cannot retain in the company itself. So there is some kind of national archive, or all the data, maybe some hospital,
so even the industry segment itself can create such this thing. For example, health sector, if you have got a medical council, let the medical council start their own kind of data-based structure so that you don't even believe the government, it's fine. Or fintech companies, they can have an archival for them so that they will be relieving the responsibility of that company taking over that, but it will be perhaps more secured, encrypted, all that you may have to do. Those of you, pardon? No. I don't know. Nothing is impossible. No. That is the responsibility of the industry association for the good of the society. Okay, fine. We are only discussing it's like a brainstorming where we can only add, we cannot delete suggestions. Okay. Okay.
Companies may buy it. AI companies may buy it because they will have lots of data and they will.
Yeah, you are.
The moment, now since you spoke about this cross-border data transfer, why don't you have a country-specific requirements to each country?
No, that is what GDPR has done. I think what the government is trying to do is more innovative. So even in the country, I am going to say that this type of, for example, Aadhaar related biometric data, I will not transfer to any company outside India, not even to EU countries.
Not necessarily for our neighboring countries. Please, I don't want to know all those.
No. I'm saying, no, I'm giving an example. Biometric data not to be transferred to any country outside India, even if it is Germany, which may say that I have the best of data protection laws in the country. So that kind of restrictions can be built in. That is what the government has now said. Yeah.
My view is that the approach that the government will take regarding the cross-border transfer of data, there are 2 points that I want to make here. Is that first thing they will say, or at least the level playing field that they will establish is any country which either provides the same level of protection or a higher level of protection. I think that is the general level playing that they will provide, saying that any country which provides the same level of protection or higher level. And on top of that, as you rightly said, they will probably go ahead with this concept of prohibited use. So there will be prohibited geographies, there will be prohibited types, there will be prohibited purposes. Like this, they're going to come out with each set of prohibitions saying that, okay, If it is financial data, I do not want the financial data that is to go to Dubai or other data to go to Dubai. But it will be a general permission to transfer. The other thing which I feel is definitely going to happen, maybe it is a matter of probably a couple of years. I think, with this data localization requirements and things like that, you will see data becoming a trading commodity between countries. And you will have some kind of understanding between countries and you will have agreements around that. I think it is a very real possibility that is going to happen as the world moves along, because people would want access to data. And they may not want to have all the infrastructure being created in the country's data where they are interested. So you will see the leaders at some level having some kind of conversation around data access to the local population. But as far as the current thing is there, I think it's safe to assume that you should be able to transfer it to the country which offers the same or better level of protection, and then the government will keep on telling you either the prohibited list or the prohibited type.
Now, there are several hands raised from that group. I'm sure that. Yeah.
So, not only that, prohibited design is already in operation. Now, there are certain aspects pertaining to defense. Anything connected, data or any distinct connected with the defense, not only other countries, even tenders, everything for some company associated with China is not permitted to do it. That prohibitory design is already in place in this thing. For data, how they are going to do it is the only aspect. They may say now that any company with the participation of China is prohibited with regard to defense.
Defense.
Then any data with reference to that is already prohibited, though it is not under this act.
Okay. Okay.
One question, sir.
Yeah, please.
I said about the contribution of publicly available private data. So, for example, there are many media companies or even Google search for data. They crawl where a lot of private data is available in the public, and and they have entire ecosystems for information integration. So, if you look at each of the publicly available data, each one of them may not violate privacy per se, but when you aggregate it or infer something from that, it can provide something different. So, is there any protection for such?
No, so one is made publicly available, no consent is required. Second, when they want to use it, if they are using it in an anonymized form, I think that is what these companies need to do. Okay, they have, when they aggregate, they have to de-identify and then aggregate.
But many companies actually
What?
profile rather than.
Okay, that is targeted advertising you want to do. In that case, seek the consent.
Even if they didn't take the consent for getting the.
Yes, see, I made it publicly available for a particular purpose. Now you want to use it for a purpose which is more intrusive to my privacy. Please take my consent for that.
Let me one more question. So whenever we give some data, so we get consent or we give consent while giving the data, but after the data is given, there's basically the data owner who's control of.
Okay, we will come to that. That will be the last question. I think we will be taking that. Yeah.
The act, the act is saying in the rules with regard to the
Regarding?
Regarding transfer data, because the act clearly said that they find the list of countries, find the native list of countries to which they cannot transfer, as long as a country's name is not there, it is still being transferred. That is what. Okay, there's one more subsection beneath it, said that if there is already existing regulatory something which is more stricter than the regulatory one, but for a moment to keep that out. Can somebody legally challenge this provision to this committee and all that thing?
Let them challenge it.
And
Okay.
Right?
Yeah, understand.
That keeping kind of a thing, it's kind of legal challenge is not what the people when they pass the vice parliament intended to. They are going beyond the.
No, it's false. That's what I called as ultra-wise. But I'm sure there is enough defense for that. Okay. Now, yeah, I think they will be asking me to close at 4:30 or something like that. That's
We can just prolong the session.
no problem. Okay. Permission granted. Yeah. Yeah.
Very of the type of the data flowing, right? Because how one is going to be segregating the data if like it is going to be the tech company or a conglomerate, like, who are going to be serving the domains in this space. And then for them to segregate the data out from the larger data sets or the data warehouses, it's very practically impossible to like, find out what is financial data.
No, no, please.
Data, what is this
Any argument that it's impossible, it is expensive, I think law cannot accommodate.
Technically, data is going to be there on your S3 buckets, it's going to be there on your cloud, which is going to be, I mean, like you cannot tell your public cloud service provider that boss, one particular copy of data, you keep it locally and one you do it in your particular area.
Who is your public?
Then
No, no, wait.
it's scary. I am to segregate that data out.
No, who is your public cloud provider? He is your data processor.
Yeah. No, okay.
So you have to bind him by contract. Otherwise, he should be considered data fiduciary. You tell the data protection board, find that person, whether it is Amazon or somebody.
I am telling them that this is the data which I want it locally and this is the data that I can have it on my cloud.
Yes.
For that, I am not getting the data out. It's very practically challenging in terms of
Challenging is a better word. Okay. Impossible is not the correct word. Okay.
Okay, and the second aspect is in terms of the trust rating, like, even the cloud that is provided need to be adherent to DPDPA.
Yes.
In fact,
Say, the Amazon. No, wait. Amazon has got a HIPAA compliant cloud service. If that is so, why can't they have DPDPA compliant storage service?
Amazon will have everything. Azure will have. DPDPA will have everything, but I need to be telling them what data I wanted.
Agreed.
Agreed. That's exactly what we have to be done in S3 bucket for all the records, for all the containers. It's not practical.
No, wait. You have to look at DGPSI framework. Please look at please look at DGPSI framework.
Other savings are very adherent to it. And what is the problem of my side? That's exactly impossible.
Okay, I think this will be going beyond the current discussion, except that classification of data is essential and you have to do it for compliance to DPDPA, not for any other purpose. Data classification has to be revisited by all organizations.
Shouldn't increase the cost of risk as well as the penalty.
Okay, in that case,
the second the level of trust that you were mentioning, if it is of the equal level of trust or the
Protection.
Exactly, protection is inherently, we are trying to gain the trust itself, right? The implicit trust. So what my point was over there, let's suppose my company is having several branches across the geographies. And in that, there could be one of the branches not being in the part of the world where the adequate amount of the protection or the trust is not pursued. In that case, are any sort of the provisions of what the GDPR languages talks about the VCRs and the model contractual clauses or the binding corporate rules, how are we trying to address those? Because I'm not going to be cutting down my entire branch over there in one particular geography from where I'm getting the revenue, because ultimately for me the business is business. So how do we get
Say DPDPA gives you exemption if you are processing data of foreigners under a contract. So if your EU processing is of non-Indians, you are exempted from DPDPA.
No. My point is, let's say suppose the branch is over there, but my data is centrally getting governed. In that case,
agreed. Say, now whose data are you processing?
Indian data is in Pakistan. My data. Indian data in Pakistan, he's saying, okay, why can't
No. Collection of data, when it originates from India, you are a data fiduciary.
Indian origin and are spread across particular geographies. I know many of them. How are we going to be getting those?
No, you are a data fiduciary, you have to find a way of processing it with a data processor who is compliant with the Indian data protection law. That's all.
I'll add one line I'll tell you. See how it is going to happen in the industry. We have a client, he's in the fintech space. What they do is that they recover bad loans, they recover overdue loans. And so they recover overdue loans through SMSs and everything. So they need to have identifiable data that, okay, I have so much. So what their model is that, the banks, they give out loans and then they sell the entire portfolio of loans which have gone back. These are because, as you know now, with buy now, pay later and all these models, and then they sell this to one fintech agency out here and they use various kinds of processes to overcome, to recover. See, the answer to your question is that, if you know, as far as my reading of the law is, nowhere has data processor been directly targeted in the law. But then what is going to happen? See, what is going to happen is each of the data fiduciary is going to basically replicate the obligation when they enter into contracts with the data processor.
Mirroring of the contract.
Exactly. So what is going to happen is that when you enter into these LSAs, when you enter into these kind of arrangements with these guys, I think there are 3 or 4 things that you have to be very critically defined. Number one is what is the kind of access you are giving them, what is the kind of use they are giving them, what is the kind of indemnity they are giving you, and what is the kind of back-to-back arrangements you have. On top of that, what we would strongly recommend is that you always retain audit rights. You must retain audit rights. The last thing that I would recommend is that once the purpose is over, you either get in a certain level audit done or a parallel audit done, whatever the party, to ensure that there is no remnant of data anywhere and it is getting depleted. So the answer to your question is, see, there is no denying that the cost of doing business is going to increase. It is going to increase. There is no way. But for the way we are moving, India as an economy is moving, the kind of thing that you have seen in the fintech space, the fintech space, with JAR and everything coming. Now the government is of the view that the same thing is going to happen in the health space, with the ASHA ID and everything. Then the government is going to take it to another, it is happening in the logistics space. So what I'm trying to say here is that I do not foresee it to be so restrictive where every operation, every kind of processing is only always going to happen domestically. It is not possible to survive in a world like this, which is so connected, by keeping everything very, very domestically. Even though we are moving towards that, it's not coming to US. Okay, but I still see that some amount of floating around is as long as you are able to put in the right checks and balances as far as the processor is concerned, I think you should be in the good. And one thing you need to be mindful about is, I don't care where your processor is sitting. I am going to catch the neck of the data fiduciary.
What processor was clear? I was talking about my very own branch as a data fiduciary setting it.
Whether it is in law or whether it is anywhere, I'm going to catch you.
Okay, I rephrase this question. Is there any instrument like SCC or something available from India to transfer?
Our objective in this session is not to find solutions and suggest solutions. But if you feel there is a need for a government approved data transfer clause, please suggest that.
We need an instrument,
Agreed. We will take that as one of the suggestions that we need an instrument for that particular purpose. Fine. Okay. What should be that this thing and all? We will take it up when some audit is being done by DPDPA and DGPSA. We will suggest what should be the instrument. Okay. Yeah.
For the
Mike.
Without mic also I can mic.
No, please take it so that it will get
Recorded. Yeah.
recorded.
I think my name is Vijay Krishna and I'm an independent advisor. Coming to the data localization or cross-border transfer. Okay. See, unlike other countries, India's scenario is totally different. We have been living in the last 3 decades, IT sector and BDC. So we have to look at the business as the interest and coming to the data privacy limitations or the control over data transfer across the border. I think it should happen over a phase of time, keeping controlled, but not aggressively, but how it should not impact various sectors. Reason is, there are different sectors and different type of data. And some sectors already have some sort of a regulatory compliance. For example, fintech, we are strong in India. So we know what to transfer and what not to transfer, and there are certain mechanisms. Like for example, some business we need to transfer. There are ways technically, you can anonymize data and encrypt and transfer and all. I think we should have fair control for data transfer and move on to strengthen those controls across. Because business interest is totally different, unlike other geographies.
Now you are the data fiduciary, you will decide how to do it. That's all.
But I just want to see, it is not a, a old thing, it's a live thing, it's a dynamic thing. I'll give you a small example. Before the Galwan crashes happened, you could get FDI from many other neighboring countries. The Galwan crashes happened and the government came out with a new press note saying that if you now want to either withdraw a Chinese national as a director in an Indian company, or you want to get money from any of the countries with which India shares a land border, you need to go and take the Ministry of Home Affairs approval. So what I would say is because let's say our relations with Canada, or let's say our relations with China, what we have to see, there is a reason we say data is the new oil. Okay, there is a reason we are saying data is the new oil. So what is going to happen is that you will see as it grows more and more. See, I'm not talking about things that will happen in the next 1 or 2 years, but you will definitely see in the next 4, 5, 6 years that these will also become important considerations in international relations between countries, and you will see government doing tap on and tap off and these kind of things as you move forward. At what level it may happen, I don't know. It is still a hypothetical that we're talking about. But what I'm trying to say is that, each geography where the data travels from India, government will look at it closely and it will keep on changing it either in terms of adding new regulations, either it will put, so let's say the government may start creating a distinction where organization X is doing the processing in India and organization Y is doing the processing abroad. They may add extra filters or extra layers for organization Y. It is possible, depending on what is the geopolitical climate at that point in time.
Okay, now we'll move on to answer or refer to a particular rule which one of our people there was asking. How does the data principal monitor how his permissions are being used, etc.? Okay, now it is for that purpose that the Act as well as the rules talk about this consent manager. Okay, consent manager is a specialized data fiduciary who can understand the complex privacy notices. Of course, government is trying to make privacy notice as simple as possible by saying that it has to be purpose specific. You cannot have one notice for 20 possible users. One notice per purpose. That is what the law says. So it will be as simple as that. For this particular notice, what is the information I require? How long I will be keeping? I will be telling you and you will agree or disagree with that when you give the consent. Second, government also says that you have to present it in 22 different languages. So by these two, they have already simplified it, but they have also gone to the extent of saying that still if there are any complex issues, let there be an intermediary called the consent manager who will be a data fiduciary. Perhaps he will be a significant data fiduciary. He will provide assistance to the data principal to provide consent. Then after giving the consent, monitor how the consent is being used and perhaps advise the data principal and also help him in withdraw the consent. Okay, this is what is the envisaged. Whether that has been fully done in the rules or not, it is a separate debatable point, but I just made a mention of it. If anybody has got any thoughts on this consent manager, you can share it. In fact, this is another business opportunity which arises out of this act. To be a consent manager is a very good activity, provided one can manage it. Yeah. Yes.
In respect of this data transfer to other countries, etc., this words used are very broad and so loosely worded that anything can be brought in or anything can be excluded.
Yeah.
It says, subject to the provisions of this act, it shall also apply to processing of digital personal data outside the territory of India if such processing is in connection with any activity related to offering of goods or services to data principals within the territory of India. Today, I may say that processing has nothing to do with offering of any goods or services. But the section, wording of the section is that processing should not be used at any time for this purpose. That's how very loosely worded or encompassing a very broad this thing. And in the rules, it has not taken, at least some specification is now provided. Rule 14 says it can be offering of goods services within the territory of India is subject to restriction that data fiduciaries shall meet such requirements as the central government may by general or special order specify in respect of making such personal data available to any foreign state or to any person or entity under the control or any agency of such state. So, in a way, ultimately, central government is going to control it. It can be country specific, it can be sector specific, but it is with reference to those notifications.
We'll go to the last major point, after which we will still continue the discussion, but at least I will complete what is
Since you're talking about the consent management and this thing, one important point or the lacuna that what I have come across is the aspect of verifiable consent.
No, that is the next one I'm coming to.
Then I'll just.
Okay, yeah.
There's a very clear call out on how they will be selected. And there is also a call out on if the concern manager defaults on the complaint,
Yes.
they can suspend.
Yeah.
There's no call out on if the concern manager goes bust. Right? What happens when they can go bust overnight, right? And they are managing millions of records. What happens to those consents and who's going to take it further? That's one point. Second point in concern manager is the operational model is also not followed up. How are they going to operate? Right? First and foremost, who will be encouraged to become a concern manager? There is no ROI for the manager really got out. How will it make is the country manager also going to ensure while there is a call out of line consent, doesn't if there is a, let's say, access request made, country manager doesn't have the rights to go and look at the data, right? That the fiduciary is going to give back or only transfer the data. So how is that going to happen? Because what if the country manager starts working like a UPI framework or an intermediate framework, unless and until they say no, and they are actually managing their data, they become a data fiduciary at the end of the day, right? I'm just trying to think aloud in terms of what will benefit somebody from becoming a concern. Is there only going to be transacting consent?
No, if account aggregators have a model of business, perhaps this also may have a model of business.
Okay. Now, I just want to extend it since we're talking about consent, children's consent, right? Now, what happens if the child becomes a right? Why till the child, until the age of 18, you are going with parental consent, you have collected so much data of that particular child.
Yes.
Now they become an adult, you retake consent.
Correct.
Right? That's point number one. Point number two is, can you use that old data? Right? If the re-consent has not been done or has not been provided, what is that mode of operation?
Again, though giving solution is not part of your discussion, but because you raised your question, verifiable consent, that's what he said. Now, for handling or processing any personal data, you have to take a verifiable consent. What do we mean by verifiable consent? First of all, you should find out whether the person is a minor or not. Second, if he is a minor, who is the guardian? If he is a guardian, then take his consent. Until that consent will be valid until this person attains majority. On attaining majority, this consent becomes defunct. It is not to be used. You have to switch over to the direct consent from the erstwhile minor. Now, at that time, you ask him whether the data which I have already collected can continue to be used or not. So it will be part of that consent switch.
Yeah, I mean, that's a long topic, but yeah, I think you gave a partial answer,
Yeah.
but, the end of the day.
Now, your problem will be how to identify whether a person is a minor or not. And that is not restricted to only those who are minors. This is something which you should do to every data principal.
I think the market will provide a business case for people to get into consent management. In fact, we know a couple of our clients.
Yeah.
We are following along with products and consent management. See, it cannot obviously be a zero-sum game for the consent manager. I think, who I can closely relate to a consent manager in today's day and age is probably among what we call the market makers in the stock market. I think the market makers in the stock market, who just whose job it is to provide a bid for every paise for the next 15 and the next 15 and to make sure that the buyers are 15. And then, and to obviously put a kind of a cap as to how much you can charge and things like that. Because, mostly it will be a tech product with very little human intervention. So, I totally take your point because, if there is no money to be made, why will people get into consent management? The other thing is that, if the government has already started with the, if memory serves me right, I think 2 crores net worth or something is required for a consent manager, right? So I think, if they have started with the requirement to have some kind of financial standing, that requirement will be constantly tested. I think that is going to happen. In the same way it happens in NBFC space or in any other space, where, a net owned fund requirement is there. If they would not have introduced this requirement, if it was a purely technical requirement, I could have taken your argument. This is not to say that things will not go wrong or, companies will not go belly up. Companies may go belly up, but I think as part of the general reporting requirement, as part of the audit requirement, as part of all the other compliances that the consent managers will have to do, I think this, maintaining a healthy, financial standing is something I think the government will keep on checking. But my hunch is that it will be somebody like what we call as a market player or market maker in the stock market, in the exchanges. That kind of role they will play.
And also they're thinking of tokenization in terms of verifiable.
See, those are the technology solutions we will have to find and we will definitely find. Okay, I think we have had.
We have had similar one already. We have GST Suvidha. It's a very good opportunity where they can be taking the source forward, where P2G connection is given. Similarly here, we have a lot of other agencies coming out like this is a wonderful economic activity that is going to happen, and there could be multitude of people because there are a huge lot of people. So in my area, I can focus upon them and I can have the data of them. And
yeah, government has also say government. Now, government. Yeah.
GST was a very good. The products is a very good opportunity.
This will open up new occasions for new business.
And there, the one of people in this is huge.
Yeah.
They have a wonderful opportunity.
Say government is also relaxing the restrictions on processing of Aadhaar data by private companies. So I think there will be some means which we will find out. It is a business opportunity. People will find out, or they can consult us. We'll tell you how to do that. Okay, fine. I think we had a very, fruitful discussion. Yeah. Data breach.
And also talking about the privacy notice.
Okay. No, privacy notice, I said. Data breach, I did not say. According to this rule, the data breach has to be notified immediately. Okay. No time is given. Okay. Immediately to the data principal as well as to the data protection board. And within 72 hours, an update has to be given. Okay. Now, the point which we have to discuss is how do we define personal data breach? This is another aspect actually, which where there is a difference between your current ISMS system and this. The incident management systems which you use, you have to redefine by saying incident includes any violation of data protection law. Okay. And accordingly, you have to do that. And now from the industry perspective, I would like your views on how do you take this immediate notification to the data principal, because once you become aware, it says once you become aware, you have to do it. How much time is there between an incident and becoming aware? The information security surveys say it takes 6 months for organizations to realize that there has been a breach. Is that an acceptable period? I don't know. And becoming aware, when my help center or call center is aware, but my CEO or DPO is not aware. Now, how do you deal with that? Call center was aware yesterday, and the DPO or CEO came to know of it 2 days later, and CEO is abroad or something like that. You are not able to decide what to do. Now, who is responsible for this intervening period? Deepa Lakshmi, you have any idea on how your company will handle this? Okay, data breach notification.
She's getting it. No, she's getting it.
Deepa Lakshmi is from Quest. Okay.
My thought process is very simple. Immediately notifying a breach. As we started with the early discussion, interpretation has to be given to the industry. I take the shelter of it. Till I call it out the incident to be a breach, will not be definitely going to report it. Okay. So corporate like us, or probably the many corporates, we try to evaluate, even we identify as a breach. Quantifying the loss and impact of the loss, assessment will be done, then only we try to notify. Even today, certain notification is there. I don't think so every organization is notifying. Maybe the same thought process will apply here or extended here in this case. Initial intimation, maybe rather than calling it out as a breach, it has to be called it out as an incident intimation to only to data privacy board. If an organization, especially industry specific or operational heavy organization has to intimate, they can intimate, or probably it is limited only to SDM. It's not
So
all organizations.
you are suggesting that the data breach or incident, okay, the incident has to be classified in such a manner that instantly it is not considered a breach. There is some time or whatever requirement, internal assessment.
Yes. Going to, they have to report to DPDPA.
Okay.
The incident, the moment you have diagnosed or probably considered as a breach, which contributes to an impact to the data principal, I think that needs to be notified. What
Okay.
process
Now, are you going to say that this is a suggestion which we have to give? That is what I want. Okay. Yeah. Okay. And what I take from her thing is that this suggestion can be provided as an improvement on the data breach notification. Yeah.
Yeah, it should be based on the risk factor. The end of the day, what's
Okay.
the harm that is going to be caused. Otherwise, one is there's either going to be a breach fatigue, right? People are breach panic, panic when everybody is going to be.
If you look at certain guidelines and definition of what is a breach, everything is a breach only. Yeah.
So and then otherwise people are going to take it like, oh, just my data, just my data. Thirdly, I don't think, see, here the definition of a data breach, even unauthorized access is called a data breach. So let's say a finance data is accessed by HR or
Yes,
some other password sharing also.
So
there should be some categorization.
Now, can the industry suggest a complete note which the ministry can adopt, or if not, at least it is part of our compliance this thing, and our DGPSA we will definitely adopt. So Okay.
All the countries, one very interesting takeaway was in New Zealand. They have a requirement that when there is a breach, you look at who is the affected party. And if you believe that the harm is not going to be as substantial, but the affected party may be a sensitive group, like a senior citizen, and you go and tell them that your password got shared. The impact of telling them that this breach happened will be higher than the actual impact of the breach. Then you don't need to go and tell them that. So it is you have to take a very calculated call. You may want to make a note, but something like that, given our size of the population and the number of people who are uneducated and elderly, I think this is a
Now,
very
as of now, rule does not provide for such discretion. Now you have to actually put it as a suggestion. Yeah, fine.
Don't give them heart attack by telling them that your data is
No, Suresh, it is like a doctor who may not tell the patient that he is going to die the day after tomorrow because he may die today itself. Okay, so okay.
Data leak with the data breach. Something like that can be suggested that, okay, so there's a data leak. This is not required to be reported, but there is not a data breach.
So there is some need to suggest something there. I agree. Okay.
The data principle. You have to do it like, the data fiduciary has to do it, but
Yes.
what medium and channel has to be.
Now the DPP will give you a web page. Okay. And you can report it on that web page immediately. That's what they will be doing in their website. You can send it by email. You can send it by email and other things. But what DPP is going to do is they will actually, when their website is ready, they will provide one section for data breach reporting. So that
they actually use this methodology of notification to saying that, okay, this is your data is breached. Please click here to revert to all those things, right? So there is always a possibility that criminals misusing this data information.
Yeah.
Right.
Yeah.
So
It's possible. Yeah, I think this thing I have kept aside. So it is only for the audience to raise any questions until Mr. Viresh Kumar will join us, I suppose. Okay. He has already come? Okay. This light is not okay. So I think yeah.
As a data subject, if I have some request, maybe to raise my data or some complaint, there has to be certain time to be defined. There have to be acknowledged within this time. It has to be resolved within this time frame. There has to be some guidance. Second thing, if I am not satisfied with the verdict or it is not there, then there has to be some regulatory framework who wants to report the complaint.
No. Grievance redressal is a mandatory requirement here, and a notice should give a link to your grievance redressal system. Okay, and even a link to the complaint corner of the DPB. Okay, this is mandatory in the notice itself. Okay, then no. First thing is the company should have a grievance redressal mechanism. And there should be a link in the notice itself at the time of collection of this thing itself that this is the link for filing a grievance redressal request. A link also should be given for complaint to DPB. Okay, so that facilitation has to be there. Now, if a grievance redressal is not resolved within the company, then it will obviously go to the DPB. If you go first to the DPB may say, have you exhausted the grievance redressal mechanism? They will send you back. Then you go. Then if the DPB gives some decisions and if you are not satisfied as a data principal, you can go to the higher level, which is the TD-SAT, and from TD-SAT, you will be going to the Supreme Court. But there is no personal remedy under DPDPB to the data principal. For personal remedy, you have to go to the Adjudicator and Information Technology Act. Okay. DPB will only.
some case happened, somebody complained to consumer person that my, at this company where they had given their data was breached and the consumer protection, this one, consumer forum awarded 1,500 rupees or something.
Personal remedy, you will not get under DPB. Okay. You can pursue whatever, you can even go on a writ, something like that directly to the court also, it's possible. Okay. Fine.
So the lawyers are done with the case goes on.
Say, if data protection law becomes more popular, then lawyers will get more litigation opportunities.
They have a way of getting some.
No, adjudicator of ITA 2000, I will recommend, don't entertain any complaint if they have not already complained to DPB. Okay. Or adjudicator himself can file a complaint with DPB if he feels it has got something to do with the personal data breach.
I just want to add to what he's saying. See, I think one of the reasons why you have not linked DPB with giving remedy to individuals is if any will just get overwhelmed. I think the idea is that they want the DPB to only deal with the data fiduciaries and the data processors. They are basically dealing with, once your data has moved along to the other side, how do I make sure that I bring them in line either by fine or by whatever means?
DPDPA also supervisory authorities only find them and money doesn't go to the individual's job.
Exactly.
But
Exactly.
you look at California, it's a consumer protection, right. Maybe we should look at for an individual, for the consumer who is giving data, if you are shopping and your data is getting misused. Instead of going to the DPDPA, they should be able to exercise their rights by going to consumer forum and it should. They cannot be stopped as of now, but maybe it should be encouraged or something perhaps, maybe.
Private rights of action.
Which is still there today, right?
It is there today.
Exactly. So I think, the idea was not to then give another forum to them. The forum that you have available today as an individual in this country still continues to remain available for
So
you.
now, my point is then will it become double jeopardy if somebody comes and to a consumer forum and then they also want to DPDPA.
No. It will be double jeopardy if you go to consumer forum and the ITA 2000 adjudicator. But complaining to DPB is for taking action against the data fiduciary, not for my personal benefit.
So you're not remedy, it's not your individual remedy. You have every right to complain against either to a DPO or to a DPP. You have written to a DPO.
If I find a consumer
is not getting then you have a next to the escalation or appellate authorities, your DPP.
No, not from a consumer forum. From a consumer forum, if I will complain like in
See,
that case that.
we have an expert on adjudication here, Mr. Viresh Kumar. We will leave it to him to actually explain it later. Yeah, I think Viresh Kumar should come over. Now, these discussions will continue and we will be happy to continue the discussion. But anyway, right, for today.
Something what we hear is, we come to know, read in the newspapers that going to compare these great ways of cybersecurity, saying data is available in the transparent. Right? What is the DPP going to do?
It depends on the chairman. If he is like a TN Session, he will take action. Okay. If he is like any other bureaucrat, he will say, let somebody approach me, then I will take action. So it is an individual thing. But if there is a notice, they can, it's all an inquiry. They can send a notice to the company and say, I understand that there is data in the dark web. What is your explanation for that? Then he can take it further. Okay. Yeah, Viresh.
Before Viresh, if you could start, let me take a privilege of introducing you. Mr. Viresh, only for the common party. I use the prefix system. He's been a dear friend. As he was the one, he was the only father of Transform. We co-founded together. And he was also instrumental in bringing Nagi sir to collaborate.
So, right, everyone up to the development.
Very good evening to you all, learned senior counsel and Mr. Navi sir, my friend Sudarshan Suresh and Mr. Vivek Tiwari, and dignitaries and industry representatives who are here. Navi sir just put on the responsibility. Adjudicator is here. Please ask any questions or grievances. Well, I'm not an adjudicator. Well, even I'm not into any industrial. I'm a senior civil judge and presently as a additional chief judicial magistrate, Bangalore. It's my research topic, my PhD research topic, adjudication process. So that's how my interest grew, and I got in touch with Mr. Navi, and he taught us information technology law in the colleges, and out of which, with the interest of the subject, I'm here. Well, friends, not taking much of your time. Well, we all know what happened with the Information Technology Act. The adjudicator, there was a provision for appointment of an adjudicator. The central government very easily, just by way of a notification, ex officio empowered Principal Secretary of Information Technology Department as a adjudicator. Well, the problem started here. Well, we know, like, of course, me and Navi sir have a disagreements. He says that you have to, whenever there's a breach of a data, you have to go back to the adjudicator. But I say you have to go to civil court. Well, we leave at that, and well, the jurisprudence has to develop on that, and there's required certain interpretations. My grievances, or like my thing, I like just want to, in a draft rules, everyone should discuss and deliberate upon this, is a Rule 18. Wherein it just one small paragraph of 4 to 5 provisions, they make member, when the member is not there, who shall hear it and how it shall be heard, and what if there's a difference of opinion, the member has 2 votes. For example, if there's a difference of opinion and the chairman has 2 votes, the chairman can say that yes, I rule in favor of this. Well, sir was saying, and even the learned senior counsel sir, Mr. Jaypatal, sir, he would agree with me. Any adjudicating body, it is only how it is dealt with. See, DPDP board is an executive as well as a quasi-judicial body. When we see a quasi-judicial body, there are n number of Supreme Court judgments. There is Tribunals Act, wherein it says how the quasi-judicial body shall be constituted. I think the legislature should have invested much more time in having the quasi-judicial body. For example, Mr. Tiwari was dealing with Competition Commission of India. Madam was saying about consumer protection, and even RERA for that matter. RERA has a hearing wing. For example, there are 5 members of DPDP board, or 5 members. A complaint is filed. The chairman is not in town. Who should pass an order is the question. And it is who should hear it. For example, the chairman is not in a station. The one member heard the matter, and another member will be passing in orders. So this is this adjudication process. If we want to see that sir is saying yes, the board should levy a fine penalty and only then the things will come to control. Well, I don't think so. Unless and until we place in a foolproof quasi-judicial body, we are not going to have any kind of a better orders from it. There is administrative difficulty. For the purpose of administration, well, yes, board can constitute. Who shall hear it? With respect to adjudication process, well, it requires a certain, of course, there is need for deliberation on that. And with respect to Section 43A of IT Act, we had a right, that is any breach. Of course, we could have sued it. Now that has been repealed, but not answered in DPDPA Act nor in the rules. Very unfortunate. So with respect to that, I have a grievances. Well, that also requires to be addressed. And very importantly, the board, even it is an adjudicative and executive board, it has a power to search and seizure. The moment there is a breach or incident of a breach is reported, the board can use its powers under CPC also, powers under the enactment also. They can immediately seize the system, immediately seize the company operations or whatever it is. That is a kind of the power. Well, it depends how a person who is manning it. It is all that dependent on that. So though the DPDP board is there, I was expecting that like under the rules, at least there will be some solace that a person who is aggrieved and the data principal is aggrieved would get some remedy or some compensation. No, he will just be bringing the complaint before the board and he takes a back seat. No compensation could be awarded. But I am of the opinion that of course the board could by writing it to the central government, the board could pass a resolution or a minutes or whatever it is. For example, there's a breach. The board could award a compensation from the penalty. Well, that's provided under the Code of Criminal Procedure, not even in the BNSS. And very importantly, the board has a power of power of a civil court. So civil court again has a power to award compensation, damages, on all other incidents of compensation. Well, in that process, I think the board is bit proactive in considering the aspect of the compensation, and if so, the end user or the person who is aggrieved of a breach of a data would get some remedy. Well, these things are taken to the appropriate government, and I, being the government servant, these are my reserved views. I reserve my views only to this extent, and thank you for all being part of here, and thank you for Trust Law and DPDPA giving an opportunity for being present. Thank you, one and all.
You did raise a very,
So please, good, I'll be there. Yeah.
you did raise a very vital aspect. I propose solution, I mean, this data protection board is being started with both of a regulating authority and as well as a dispute resolution mechanism. So my proposed solution to this is we might have to represent the government to have two parallel authorities. For instance, an RBI, which is a regulating authority, and at the same time constitute another board, which will just be a kind of a dispute resolution.
Yes, Sir, Jay.
Data or access to data or the resources to prove whether it's okay or not okay. But what I have done is from my understanding and by my source. So they will penalize me as they were giving the compensation. The two penalization is rightly mentioned that, and to the act. In such an event, is it not a kind of a regressive approach towards the freedom of the individual?
Sir, there are two legs with the comment or question what you made. One is the compensation aspect and the penalty aspect, and another is a person, victim, a person, just a insurance policy holder. We can't expect him to have all the infrastructure to show that a person has breached that. With respect to first aspect, yes, penalty, it's to the Consolidated Fund of India, not to the person who has lodged a complaint. So amount goes to direct to President of India. Second aspect. Under Order 26, the board has again a powers to appoint an expert committee, to appoint data cyber security experts, to see to that, and even to assist the board whether if there's a breach, the board could it can appoint a commissions or appoint an expert committee to see that how there has been a breach, whether there is a real breach, if there's a breach, up to what extent, and what is the magnitude of the amount person has lost, and it can assess a report. A report can be given, a breach analysis report can be done. Based upon that, the orders can be passed. With respect, I'm very even in the last summit also, I just discuss throw a light upon that. There should be we are interpreting penalty in a very narrow order. Of course, penalty goes to the government of India. That's it. One word. Only the compensation, and the board doesn't have a power. It can't go beyond section rule 18 of DPDP rules to award, to give a compensation. When the law doesn't provide to give a compensation, the question of awarding compensation doesn't arise. However, the board being proactive in the part of the compensation, for example, 1 crore is the penalty, the board can give that he is to the extent of this, he has a breach, and that can be. For example, I take an insurance or term insurance of 1,000 rupees per year, and I can't expect 15 crores compensation. And very important, I just forgot to mention, sir, the tenure of the board chairman and the members is 2 years. I'll say how this doesn't work here. In Karnataka, as of now, the adjudicating officer has only 24 matters and pending since last 4 to 5 years. Even to right now, 25 matters, and since 2011 to till this day, 2 to 3 petitions are filed by Navi sir. Are only 25 cases are disposed from 2011. But see the incident or the breaches every day, day in and out, because this happens in such a way. Quasi-judicial bodies or the adjudicating officer, what it happens, they don't sit regularly. That is the problem. See, in my last 10 years of my service, even Jacob Patil sir would agree with me. How effective are the judicial bodies? take example, the civil court or the district courts or even the high courts or Supreme Court, you get your next date. When is your next date? High court has a listing system, but in the trial court, you'll get to know what is the next stage, next date. And you can tell the court, sir, this is my last stage and this is what happened. Kindly close the stage and go to the next stage. And that happens. And you can't do that before adjudicating officer, because the adjudicating officer, if he's not there, he'll not assign the dates. I have practically seen the executive or the person, PRO or anything, he will say, the advocate will come and he will say, sir, the principal secretary is in a meeting or he has gone to Delhi, please come next date. He will give after 2 months. After 2 months, you have to come. This is the system, what happened with the adjudicating officer. Of course, the government could have addressed that, appoint a person or a judge or a full-time adjudicating officer. They did not do it because maybe probably I feel that there were not that much of a cases. Even the government did not expect that there could be a flood of a cases. Even to the DPDP board, if at all it should work, it should know to handle the volumes. It's an only body to the whole of India. RERA, it has in every state. Other bodies, every state has its organs. Of course, it's in a digital office, it's a digital body. But volume, you just see, just one complaint is lodged from one city. Then Karnataka has 31 districts and 272 taluks, and every day will not have less than 100 complaints. And for a year, 3,000, something more than 3,000. And how many complaints would be disposed of? Here.
That is a very important aspect.
Don't get?
Not for lack of quorum of the bench.
Yeah, of course. I mean, the Rule 18 requires furthermore clarification. It could have a judicial wing, because the enactment prescribes that a person from a background of law, technology shall be there, and everything. In that case, they should have a judicial wing which regularly sits on the matters. So coming back to the tenure, where's the tenure? The select committee consisting of a principal secretary of IT department and law and justice would constitute a committee, and they would appoint a person for the 2 years. So if the person, the moment if the appointment process, if completes by next 2025, the process of selection should start way back in somewhere, by its ends by December, it should start by November or November in the way. If it doesn't, the members will vacate their offices and the complaints will be lying there. So it should be like a cycle. For example, if it is a 2 years, for 1 year, 8 months, a process of appointment should start. In reappointment also, it has to be by Government of India. You know how fastly the files go from ministry to PMO to from again to the President of India. And there are many substantial cases or substantial files that has to reach to Government of the President. The President has to sign it. If at all it has to be appointed. Of course, it's a main legislation. Of course, that requires an amendment. If the tenure is of longer period, then something the board members and the chairman could really do or pass some orders or anything. For example, for the purpose of inquiry only, we require they require 6 to 8 months. Sometimes in complex cases. Well, this is what with my limited knowledge I could place before this August committee. Thank you for the opportunity.
To add up to what all dignitaries spoke and the questions which were raised, to quote an example, in Anna University's sexual assault case, High Court granted compensation of 25 lakhs for the name of the victim. See, it is not just the authority under the DPDPA Act. It's the power to adjudicate the matter. It is not just a consumer court or consumer commission which can adjudicate the matter. So wherever this digital data is, personal data is misused, the forum are actually way to levy the compensation by evaluating the gravity of the damage done to the victim. That's one thing. And so everyone went to the core of the matter. So summing up, I will bring everyone back to the outer layer of the matter, today's discussion. We come from the era where our names were displayed on the train compartment outside. We would have been so happy for names are displayed. Today, we are the era. We are very finicky if our names are displayed. So India is going ahead in a proper direction. That's what I feel.
There was a reason during that era that data was not that heavily digitized and used frequently that it could be, traced back to an individual.
Then we did not have an idea of exporting the data for commercial purposes.
Exactly.
In today's era, why this data is very, digital data or whatever kind of analysis is there. Because we can exploit it commercially. One, exporting it commercially, while exploiting it commercially, whether you are going to exploit it legally or you are not going to exploit it legally or illegally. So as long as you are exploiting it legally, it's permissible. When you are exploiting the data for the illegal purposes, so then that's where this act moves everything will come into question. So giving an anecdote, I was opening a bank account, I was just filling all the pages in so that we will do the case. Approved and sufficient. My brother passes by comment, stating that, oh, typical Indian. So that's what it struck me, it is very important to go for everything. We Indians have a mentality, so sorry, but we have to outgrow that mentality. Every law from the day one, the constitution has come into picture, has been kept open in the public domain before it could be made as a law. The draft rules, the draft enactments are placed before the public. This is the place where we are expecting everyone to share their views that, this is not the right thing, it should be this way. Only the industry people can tell that because you people are the one who would work with that, the technology as well as the law, and you can see the friction. So we want to identify that area where there is a friction so that, accordingly we can recommend to the concerned authority. That is what the intention of our meeting is all about. And now, what happens if we do not contribute anything before the friction? Within 18th of limiting my talk to this particular route within February 18th. Then you figure out the friction once the law is clear. Then you say, it is not viable, it is constitutionally violating, it is violating this provision, fundamental rights, constitutional rights. But, then you have to come back to please come up with the friction where you find and give the information so that we can compare it and
our apologies due to the paucity of time. We are forced to go for wrap it up. So any other pointers if you are still to be asked about the enforcement authority or consent management? So we have kept a platform open. You can do so. So may I request Ramesh to come over for the and Naran.
So we are We are happy that Trust Law has got associated with FDPPI, and we have organized a beautiful session today to discuss on the DPDPA rules. We were wondering whether we will be able to completely utilize the 2 hours. But when I attended the section, I was very happy that even if we had a 5-hour session also, we could have interacted, sir. That was really good, actually. Really, I was wondering whether 2-hour session would be enough, sir. Should have it a 1-hour session, actually, when discussing, okay. But we had so brilliant people in hall. That session was so productive that we were wondering how the time went. Isn't it? So it was really good, and we are very happy to have Navi sir, such an intellectual person, to address the gathering today. So thank one and all. So we have the space now. We are ready for the IT now. We can have it. So who is going to have a point of session? We'll do that. Thank you. Thank you. Special gratitude to our seniors.
Yeah. So special gratitude for all the attendees who attended this event, and also my heartfelt gratitude to Senior Advocate Mr. Jayakumar S. Patil, who was kind enough to accept our invitation, taking some time out of his busy schedule. Thanks a lot, sir. It was quite an enlightenment and enriching session. And not the least, a heartfelt thanks to Mr. Navi, sir, who accepted our invitation to collaborate for this one particular event. So thanks a lot, sir, and hope to do a lot more sessions in future, similar sessions in future.
Thank you. Thank you.
You just check this one. One more. You just check.
And after the high
Are
tea,
they-
everyone is
Yeah.
requested to join for a joint photo session.
That's it. Thank you. Okay, take this. What mic is this one?
This one actually, there's a speaker there.
In this.
Actually, what happens is the camera doesn't capture the
Audio. Okay.
So we kept the speaker there and we're using that.
That's okay. I thought you're using separate for that.
Because this mic, whatever you use, the camera
Really capture that. Okay. That has been our experience in this fine. Thank you, sir.